Hello, everyone, and welcome. Today, we're diving deep into the very specific, very precise English you need when you're communicating a data breach. For any international lawyer, this isn't just a useful skill, it's an absolutely essential one in today's world. So let's just get right to the heart of it. In the world of cybersecurity, data breaches are a matter of when, not if. It's pretty much inevitable. So the real question for you as a legal professional isn't if your client will face one, but are you truly prepared to handle the communication when it happens? Because at that moment, your ability to be precise and authoritative is everything. Okay, so let's start with the foundation, the legal definition itself. Now, I want you to really notice how broad this is. We're not just talking about some hacker in a dark room. This covers accidental loss, someone unlawfully changing data, or an unauthorized disclosure. Every single word here has serious legal weight, and it really forms the basis for everything we're going to talk about today. First up, we're going to master the core vocabulary. Look, in a crisis, any kind of ambiguity is your worst enemy. For a lawyer, your most critical tool is using exactly the right term at the right time. This is the language of instant response. The first term you have to know is IRP, the Incident Response Plan. Just think of this as the playbook, the game plan that an organization absolutely must have ready to go before anything happens. It's the documented strategy that tells everyone what to do, from containment all the way to notifying the public. Honestly, one of your first questions should always be, where is the IRP? Next, we have the forensic investigation. This is basically the detective work phase, both technically and legally. You're trying to answer what happened, how did they get in, and, this is the big one, what was the scope and the impact of the breach? The answers you find here are going to dictate your legal obligations and your entire communication strategy. And that investigation naturally leads to remediation. Now, this isn't just about cleaning up the mess right now. Remediation is a forward-looking concept. It's about documenting all the actions you took to fix the security holes and, critically, to prevent the same thing from happening again. You can bet that's a detail regulators are going to be looking at very, very closely. Now let's talk about one of the most common ways these things start, phishing. This is a cyber attack that really exploits human error, right? It tricks employees into giving up sensitive info, usually through a fake email. As a lawyer, you need to understand this term inside and out, because it's so often the root cause you'll see in those forensic reports, and that has a direct impact on questions of negligence and liability. All right, let's try a quick scenario. Your client calls you, they're in a total panic. An employee clicked on a suspicious link, and now there's unauthorized access to the network. Based on what we just covered, what was the attack method most likely called? Exactly, phishing. And you see, this is how this specific vocabulary applies directly to the real-world situations you're going to be advising on. Being able to name the problem correctly is the very first step to controlling the legal story and the public narrative. Okay, so we're going to shift gears a little bit now, from vocabulary to grammar. And I know, grammar. But trust me, how you structure your sentences to talk about events over time is absolutely critical in any kind of legal reporting. We're going to look at how to describe adaptation and change. Let's break down this really subtle but incredibly important difference. When you say used to plus the base verb, you're talking about a past habit that's over and done with. It implies things have changed, hopefully for the better. But when you use to be or to get used to plus the ing form of a verb, you're describing a process or a current state of familiarity. The choice you make here really shapes the whole story of your client's compliance journey. Let's put this into a real legal context. Look at the first one. Before GDPR, companies used to share data freely. That describes a past state that's no longer compliant. Now the second one. It took weeks for staff to get used to documenting every activity. See that? That shows the process of change, of adapting. And finally, our CPO is used to collaborating with international counterparts. That describes a current, established skill. See how each one tells a very different story? All right, next up in our grammar section, defining data boundaries. You might think prepositions are just tiny, simple words, but in legal English, a word like in or out can actually define liability, jurisdiction, and who is in control of the data. The difference here is just fundamental. In suggests containment. It suggests compliance. For example, data is stored in a secure database. Out, on the other hand, well, that implies movement and, more importantly, a loss of control. Information was leaked out of the network. That one little word can be the difference between data being legally secure or legally compromised. And look at the legal power these prepositions have in practice. Saying a breach originated in the internal servers helps you define the scope of your investigation. But a law that prevents data transfer out of a country, that sets a hard legal boundary. And when you report that data has moved out of the network, you're making a very serious legal statement about a loss of control. Okay, so let's bring all of this together. We've got the vocabulary, we've got the grammar. Now let's apply it all to that high-stakes moment, actually communicating the breach. And let's be really clear about why this communication is so important. The financial hit from a data breach is just staggering, and it keeps going up. This number isn't just about fines, we're talking about legal fees, the cost of notifying everyone, and all the remediation work after the fact. How you communicate can directly affect that bottom line. But, the cost isn't just about money. This quote's focus on goodwill, that intangible value of a brand's reputation and customer trust, is so key. A breach can destroy it overnight, and that kind of damage is often way harder to fix than any technical problem. As legal counsel, protecting that goodwill is a huge part of your job. So, picture this. You have to make that first urgent phone call to a colleague, maybe someone in PR. Your goals have to be crystal clear. Number 1, inform. State the facts clearly. 2, reassure. Show that the situation is being managed. And 3, instruct. Tell them exactly what the immediate next step is. This is all about control, not panic. Now just listen to the language in this example. We have confirmed a data breach, working with experts to contain it. The situation is under control. It's direct, it's confident, it uses active verbs. It doesn't downplay the problem, but it shows that a professional process, that incident response plan, is already in motion. That is exactly the tone you need to strike. And that brings me to my final thought for you today. Your client's data has been leaked out of the network. What's the very first verb you use? What's the first action word that comes out of your mouth in your communication? Are you going to contain the breach, assess the damage, mitigate the risk? The word you choose sets the tone for absolutely everything that comes next. And that, right there, is the power of precise legal English.